Perfect. Thank you. Good morning, everyone. I'm Matthew Cherry, Senior Counsel for TABC, and I'd like to welcome everyone back to in-person stakeholder meetings. So we haven't had anyone attend in person today, so I do want to remind everyone that these are open back up if you want to attend in person, but as always, we'll still do these via Zoom. And then I'll also add, today is not the only day to provide any sort of comments or feedback on the proposed rules. You can always send those in after this meeting. You can send those via email to our rules inbox at rules@tabc.texas.gov. We have 3 items on the agenda today. I'm going to go through them in order. We'll go through the changes, and then at the end of each item, I'll open the floor for comments and any feedback, and then we'll move on to the next ones. So first up today, we have agenda item 1, which is revisions to Chapter 50 relating to alcoholic beverage seller, server, and delivery driver training. So these changes address the new training required by Senate Bill 998. And some of it removes a little bit of outdated language. So what Senate Bill 998 did was implement a new opioid-related drug overdose training program required for certain retailers. Our goal right now is we're going to incorporate that into the current seller server training, plus the opioid-related drug overdose training will be a standalone training on its own. So because the training is being added as a new piece of the regular seller server training curriculum, we amended Chapter 50 to up the time limit that is currently in the rules from 120 minutes over to 140 minutes because we anticipate that training is going to be about 20 minutes. So that's kind of the background of what we did. I'll start with these changes down here. The first one is in subsection F of 50.3. You'll see that we struck out a bunch of language that pertains to the initial training curriculum that was set up back when this rule was first adopted back in 2010. So a lot of that language is no longer applicable since the curriculum has already been in place. So all we did is remove that surplusage language, and then now we're going to be going forward. Any changes to that curriculum, the agency will still engage with industry, and we're also going to post on the Texas Register and the Commission's website. The next changes you're going to see are in sections 50.4, 50.5, and 50.6. All of those changes are the same. All they do is change the amount of time for that training from 120 minutes to 140 minutes. And that is just the 20-minute increase because of the new opioid-related drug overdose training. And I will add that there is one additional rule that I ended up finding that does have that same timeline in it. It is Rule 50.29 and subsection A1 of that rule. And that pertains to the requirements for issuing the actual certificate that the individuals receive once they complete the training. So whenever we propose these to the commission, just be aware that you will see one additional rule on this, and it's this exact same type of change, just changing the 120 minutes to 140 minutes. So that covers all of the proposed changes that we have right now for Chapter 50. So I will open the floor to any questions or comments.
Matthew, Marcus Schwartz, can you hear me?
I can. Good morning.
Good morning. One question or kind of overall thought here. And you said correct, you guys are going to roll out a separate drug class as well as roll it into, general seller server training, correct?
Yes, it will be a standalone training as well. And that's mainly because, as you're aware, the current seller server certificate that gets issued for 2 years, and by the language in the statute for just the piece relating to the opioid overdoses, that is for the retailers that it is required for, that is a yearly one. So we need that to be a standalone thing. So it'll be incorporated into both by itself and then also into the main seller server curriculum.
Gotcha. And with respect, obviously, I have a lot of clients that do not have these permits, and there are a lot of retailers that don't have private club or MB permits. And so, tacking this on to the normal class, I get it, it's convenient and the like, but it's just an additional time and expense for these people for something that doesn't necessarily apply to them under law.
Okay, that's duly noted. We appreciate that feedback. We'll have a discussion about it, and potentially make any changes that the agency wishes to make, before we propose these to the commission.
Understood. Appreciate it. That's all I have.
So we do have one question from someone online as well. It says, so for clarification, would the opioid training on ServSafe, would it be an add or separate? If I understand your question correct, it would be both. We are adding to the current seller server curriculum, and then also there will be a standalone option for the opioid training all alone by itself. And if that doesn't fully answer your question, or if I misunderstood it, please type back in and just let me know.
Greetings, Matthew. This is Amy Harrison.
Recognize that voice. Good morning.
I bet you do. I'm just curious if someone doesn't complete this second part of this training, what is the penalty to the permit holder? Or can you explain that to me if the employee doesn't engage in that additional training or it lapses?
Do you mean when it's incorporated into seller server or all by itself?
Either one.
Well, first off, that would depend on if the employee is, an employee of one of the retailers that it is actually required for. Then there could be an issue in that the agency would assess that and look at the situation like we do with anything else when assessing a potential violation. Outside of that, for most retailers, this is not legally required. Obviously, taking the seller server training does play into potentially getting safe harbor. So the vast majority of our retailers, do have their employees take this, but that doesn't mean that it's required for everyone. So for many employees, it won't be required. And if they do not take it, there's no impact on the license or the permit holder.
Thank you.
We have another question. The addition is for future certificates, correct? And the current certificates are still valid. That's a great question. To answer the first part of it, yes, this would be for future certificates. And to answer the second part, yes, they are still valid. Once this change goes into effect, that does not then all of a sudden nullify any of the training that someone previously took. Absolutely. All right, it looks like that is all the questions that we have on this one. I will get ready to move on. If anyone else has something they want to add, please speak up now or just type into the chat and we can get back to it if needed. Oh, we did get one extra question. It says the changes go into effect on what date? And I'm assuming that you mean the changes that are proposed right now in this rule versus changes to the actual curriculum. Is that correct? Got it. Okay. Yes. So I do not have a hard and fast date specifically for the rule, just because there's a lot that goes into that process. I can tell you right now, we anticipate that these rules would be effective sometime in February. That is obviously somewhat dependent upon what happens today, the feedback we get after the stakeholder meeting, and then also the feedback that we get from the commission once these get proposed, and if there's going to be any changes to that. Normally, we have our stakeholder meeting, then the proposed rules have to go up to the commission to formally propose those at a actual commission meeting. Then there's a waiting and a formal comment period, and then we will have another commission meeting after that where the rules could actually be adopted. And then there's a small waiting period after that before they could legally be effective. And right now, providing everything goes well, and we don't need to make a bunch of changes to what we're currently proposing today, we anticipate that these rules will be effective in February. But that's kind of the best timeline that I could give you at the moment. We have another question. Can we access a copy of the recorded meeting?
Yes, it'll be on board docs.
Okay, yep. A copy of this meeting will be recorded and it'll be available on board docs. All right, it looks like that's all the questions that we have for item number one. Please remember, if you still think of something that you want to ask, I'll do another kind of follow-up at the very end after we get through the other two items, and you can still ask any questions or make any comments on item one. So item two pertains to revisions to chapter 33 for events at a temporary location, and rule 41.25 for providing samples to by distillers and rectifiers permit holder. And this incorporates provisions that are required by Senate Bill 1375 and Senate Bill 926. So just as a little bit of a background, so what the legislature did, there's new changes in section 1409 of the code that authorizes distilleries to have temporary events. It's very similar to a lot of the other temporary events that we currently have in statute for retailers and for wineries. The main difference with the distillery sections in 1409 is it does not authorize distillers to actually sell the samples. They only can provide them for free of charge. So there's no sale. So you'll see a lot of conforming changes to that. Where the rules previously referenced sale, we also added in some language to allow, for the service. The other big change that we're going to go over is there was a fix to chapter 28 for mixed beverage permit holders and authorizing them to conduct temporary events at a certain racing events. And so we've also added some rules that incorporate those changes in statute. So the first changes are to section 33.70. It's subsection A. This is just some basic cleanup. We did realize that initially it said that this rule relates to all these chapters when really that should be the actual subchapter. So we just changed rule to subchapter, and then we added in chapter 14 for distilleries to the list of license and permit holders that the temporary event rules are applicable to. Next change is in rule 33.71. You'll see subsection A4. One of the requirements for file and use notification that we had previously in the rule was that the event is not sponsored by a member of the wholesale tier or the manufacturing tier. So we added an exception to that for events that are conducted pursuant to chapter 14 or 16 of the code, and that's for distilleries and wineries. We believe this just made a lot of sense since distilleries and wineries are already in the manufacturing tier. There's no way that we could prohibit them from being a sponsor of their own event. So that's just an exception for those two permit holders in there. And then you'll see another change in subsection A5. All we did there was add or service after sale, just to incorporate the authority for distilleries to only provide samples instead of sell the alcohol. Next set of changes are in 33.72. So we'll see a change first in subsection A. It just adds an exception that relates to subsection B for the timeline of temporary events for certain racing events. So the general standard right now that's been in rules in subsection A, and it's been up to 4 consecutive days by statute in section 2820 of the code for the temporary events that are conducted at certain racing facilities. There is a different timeline set by that statute, and it is up to 5 consecutive days or potentially up to 6 days if that's necessary to accommodate the postponement of the scheduled racing event due to an act of nature. So all we did there was add that, incorporate that into subsection B, so that's clear, and that's a little bit different than the standard 4-day time period. The rest of the changes to the subsections in 33.72 are just conforming changes since we added in a subsection B and just moved everything down. So the old B became C, old C became D, et cetera, et cetera. Next set of changes are in rule 33.76, subsection A, subsection A to D. This is very similar to the one that we just went over about the sponsorship piece for distilleries and wineries. So if someone is using the file and use process, one of the current requirements is that they provide a sworn statement stating all these various things that are in the subsections. And a part of that sworn statement had to be that the event is not sponsored by a member of the wholesale tier or the manufacturing tier. So we just added an exception for the distilleries and wineries for that, since again, just like we did in the previous rule that I just went over, they're already in the manufacturing tier. So obviously they need to be able to sponsor their own events. And the last change you'll see in 33.76 is a new subsection F down there, or actually it's A2F. And all that is adds in language talking about verifying the wet dry status of the governing jurisdiction where the event will be held. This is just because the statutory language for the temporary events, when it talks about the directive to the agency to promulgate rules. One of the pieces of that is specifically a process for verifying the wet dry status. So we added that in just to accommodate what the statute required. Next set of changes is in Rule 33.77. The first one is in subsection D there, and this pertains to requests for temporary event approval. So in subsection D, we added in the verification for the wet dry status, just like we did in that prior rule for the file and use notifications. And then also for the request for temporary events, there's a new subsection F, and this allows the mixed beverage permit holders that are pulling that temp event permit at the racing events to submit something to the agency in writing, just a notice to the commission that there is that active nature and that their event will need to be extended from that initial 5 days out to the 6 days. The next set of changes are in Rule 33.81. The first one is in subsection D. And then the next is in subsection E. And this is really just because of the specific language in the new section 2820 of the code. Previously, this rule pertained to all sorts of temporary events and where the mixed beverage permit holders needed to be purchasing their alcohol. The old subsection D there did state that the section does not preclude the mixed beverage permit holder from transporting alcoholic beverages that are already in stock at their primary location to the temporary event. For the new section 2820 in the code, specifically for mixed beverage permit holders doing temporary events at the certain racing facilities, the language in 28.20 actually specifically says that they have to purchase it. Let me back up. It says that if the event is held in a county that is separate than the county of the mixed beverage holder's primary location, then all of the alcohol has to be purchased from the wholesaler or distributor that is actually in the county of the event. So that's why we did this exception here to what that general standard was, authorizing the mixed beverage permit holders to transport alcohol that was currently in stock at that location, and added the subsection E. And this really mirrors the language that's already in statute. We just thought it would be best to add it in the rule for clarity. And because that old subsection D did specifically authorize transporting the alcohol from the primary location in, let's say, County A to the event location in, let's say, County B. And then the last change we have for this item is in actually Chapter 41 pertaining to auditing, and it's in Rule 41.25. So this is very similar to when the distilleries receive their authority to provide samples over to retailers. That's when we kind of created this rule and then made it clear that the taxes do have to be paid on those sample sales. This is a very similar type of privilege that distilleries have received in the new 1409. So we added this into that list. And this is really because of the definition of first sale in section 201.02 of the code. All right, and that covers all of the current proposed rule changes for item 2. I will now open the floor for any questions or comments.
Thank you, Matthew. It's Amy again. My first question or just comment is in the last rule, you specifically point out 1409, and I don't know if it wouldn't be beneficial to those that don't want to scan all of chapter 14 and 16 to find 1409 and 1608 for you in those other areas to give the specifics rather than just the chapter. That's one comment.
I see. Okay. Yeah. Instead of saying chapter 16, maybe give the specific section of the statute that authorizes that privilege. Okay.
Right.
Really
14.09, 16.08. Then my other comment is not really, I'm just taking an opportunity, you know, what a pain I am. But with the temporaries being changed from the historical 10-day to 4-day, it's certainly, I'm suspecting, has increased the workload of the division. And I'm just curious if this might be an opportunity to do some statistical analysis of what that increase has caused by decreasing those number of days. Historically, they were 10 days so that they could capture 2 weekends. And if allowed to go for certain specific locations, additional days, I'm just curious if this might not be an opportunity to look at the 4 days and see if that's a good thing for everyone, or if there might be consideration to perhaps lengthening that. And then my last thing that, again, I'm a bit of a pain, would be that I appreciate that the statute directed TABC to confirm wet dry status. I think that's very important. And currently, the applicant is able to confirm that by just admitting that they have confirmed that it is wet for that type of event. Whereas the owner of premise permission requires a signature. And so when you're doing these events that are going for 2 weekends or however many, you're pushing that paperwork to the property owner every single time for his signature, which is time consuming for a lot of individuals, including TABC, when people don't get the proper signature. And I'm just hoping that perhaps in that process, because wet dry status is just confirmed by the applicant's statement, if perhaps you might not consider changing the process, allowing the applicant to confirm with affidavit that the property owner has extended this privilege to them.
Okay.
That was a lot of words, and I hope I didn't lose anybody, but that's a thought.
Good thing is we have this recorded, so I can always go back and listen if I missed anything.
You can always call me and say, what the heck did you mean, Amy? And please notice I tried not to curse.
Yeah.
So thank you very much.
Okay, no, but I think those are great comments. We'll have a discussion to discuss those. One thing I will say in regards to the timeline and the authorized number of days for the temporary events. Right now, what we have, in the rules, even prior to these current proposed changes, is a framework that works for everyone that is getting temporary events. Is one reason why we have that 4-day standard. And the other reason is because for some of those retailers, specifically in statute, it is 4 days. So by rule, the agency still wouldn't be able to go in and all of a sudden just increase those altogether. But that might make sense maybe for some that don't have that specific timeline, but that is one reason that 4 day is already in there. So I just want to kind of respond to that and let you know that for some of them, there's just no way that we're going to be able to make that change via rule. Just because we don't have that authority would need to be done by the legislature. But otherwise, we can definitely take a look at this and also look at, how that has impacted maybe licensing, processing, and workload as well.
Absolutely. And thank you. And by doing that statistical analysis, you might be able to go back to the ledge and say, maybe that wasn't the best decision, but that's just a thought. Thank you. Thank you.
Don't know if we would phrase it that way, but I understand exactly what you're saying.
Never would you phrase it that way. They're so intelligent and wonderful. Thank you.
Thank you for the comments. We also have a question from Amber Hausenbluck. It is said section 1409 allows a distiller to conduct samplings/tastings at a civic or distilled spirits festival, farmers market, celebration, or similar event. The way I read the file and use notification is that the event has to be private and not open to the general public. How does this work when a distillery wants to participate in a farmer's market that is open to the public? Okay, so Amber, you are reading that section correctly. But that requirement only pertains to the file and use notification. The way that the rules are set up currently with these proposed changes, that does not prevent a distiller from filing a temporary event approval and still conducting that event at the farmer's market that's open to the general public. So in this sense, it just would mean that that type of event does not currently qualify for the file and use notification. It doesn't mean, though, that there's no option for the distillery to have events at those types of farmers markets. It just means that currently the way that the rules are set up right now in these proposed changes is that they would have to file for that temporary event authority. You're welcome. All right, I'm not seeing or hearing any other questions. I'll wait just a little bit, see if anyone else has a question or comment or any other feedback on item number 2. And if not, if you think of it in a little bit, you can always respond at the very end. That's not a problem. All right, I'm going to move on to item number 3. So this is a proposed revision to Rule 45.117 subsection C2 pertaining to the limitation on the dollar amount of advertising specialties. So what we've done right now in this proposed change is it's not a change to the amount that is already in the rule. This is merely just a change to the process for the agency setting that amount. By statute, it does say that the executive director can issue an order without having to go through the whole rulemaking process to do this. We thought that was just a smoother way of working with industry and setting this amount for the advertising specialties. So all this does is change that process instead of it being in the rule to just making it clear that the executive director will issue an order that sets that amount, and that order will be published in the Texas Register and on the commission's website. And one thing I do want to add with this also, our intention here is not to set that limit in a vacuum at all. Before that actually gets finalized and that order gets issued, the agency will still be engaging with industry, receiving feedback and comments before we go through and finalize everything. All this does is just currently change the process from taking it out of the rule and making it clear that it's going to be set through an order issued by the executive director. That's the only change that we have for item 3. So I will open the floor for any questions or comments.
Hi, it's Amber Housenblut. Can you hear me? Hi. Does this mean that this will just be published once a year before the calendar year? Not that it can be changed multiple times, since the way that I read it, it's, you know, the executive director can change the amount or establish the amount per brand per calendar year. I just want to make sure that it's not going to change throughout the calendar year, that amount, and then someone then get in trouble for exceeding that amount.
Okay, no, I understand. No, it's not going to change multiple times. By statute, the authority to the executive director to set this dollar limitation, it could only be done on an annual basis anyway, so it wouldn't happen multiple times throughout a calendar year. But the other thing I do want to point out, the piece of it that is also talking about per brand per calendar year right there, that also does relate to the actual way that the dollar limitation gets assessed for providing those advertising specialties. So that's why some of that language is already is still there. But it doesn't mean that we're going to have multiple updates throughout, you know, a calendar year. I think that would make things confusing, and also that wouldn't comply with what the statute says the authority is to issue this dollar limitation.
Right, I assume that. I just wanted to make sure.
Okay. Yeah, absolutely. All right, I'm not seeing anything else for item number 3. Does anyone have any questions or comments on the first 2 items or still item number 3?
Matthew, Marcus Schwartz. On our first item, seller server training, and you guys may well already have decided this is a way to do it, but I would just say, because, you know, most applicable, I think this is going to go to safe harbor, right? Whether someone qualifies or not. And I don't think anyone knows right now when this program is going to necessarily roll out. So I think for enforcement purposes, and it would certainly help the industry to know, hey, TBC is going to expect everyone to have complied with this by X date, right? Do you follow me? For purposes of qualifying for the training, right? Because, you know, say we roll it out on Friday, right? I don't think it's necessarily realistic to believe everyone on that Friday throughout the entire state is going to be registered on that date. Follow me?
Yes. Yep. Nope. I can understand that. Yeah. As of right now.
That's my only comment.
Okay. I would say as of right now, because of the timeline of when the rules actually would not go into effect, I mean, we're anticipating, I think at the earliest sometime around, February. The curriculum and everything set up already and in place before then. And we'd have a lot of communication with industry to give everyone time to start maybe taking that training before the rule even actually fully goes into effect, to avoid kind of that type of issue that you just described.
Perfect.
So I believe, have our timeline would, like I said, avoid that. So it's kind of the best we can do, and that's what we are anticipating.
Excellent. I appreciate it. That's all.
Thank you. All right, that looks like it's all we have. I'll leave it open just for maybe another minute, just in case anyone else has any questions or comments they want to make. And also, I'll add, like I said at the beginning, this is not your only time to do that. Feel free to send out an email or give us a call. And again, if you want to send over an email, the best place to send that to is rules@tabc.texas.gov.
Matthew, my name is Karis. Can you hear me? Would it be okay if I ask some clarification questions? My knowledge is probably not up to par with everyone else's, but I just wanted to see if I could get a little bit more clarification on the second item we went over.
Absolutely.
As far as the days, the consecutive days, the 4 days that it's changing to, what was it prior? So for example, like an event like Austin City Limits, where it's 1 weekend and then 2 more after that, I believe. Would that be, if a distillery or winery was participating in something like that, would they be having to get an sorry, I lost my word for the temporary permit, sorry. So would they be getting a permit for each weekend? Is that what I'm understanding correctly?
Yes, because of that timeline, yes.
Sure. Okay. So that's perfect. That's all I needed clarification on for that one. And then as far as the different county, what is it right now that is changing? So right now, before this goes into effect, what is the rule for a different county of or an event that's in a different county than a distillery or winery?
Okay, so you're then talking about the changes to Rule 33.81. So that rule is actually
Yes.
specific to mixed beverage permit holders. And
Okay.
then, right, so that actually does not impact at all the distilleries and the wineries and their temporary events.
Okay. Then that was my clarification question. I appreciate it. Thank you so much.
Hi, it's Amber Housenblick again. So now that distilleries are going to be able to, file these or get their temporary events approved, are they allowed to serve samples, I guess, at a nonprofit temporary event? Because right now, the way I understand it is they can donate but can't, bring it or serve it. But now that this bill says that they can participate in celebrations, would they be able to file a temporary event approval and then serve samples there?
Yeah, if they receive the temporary event approval, then yes, they would be able to serve samples.
Okay. Thank you.
Yep, absolutely. I'm not seeing anything else on that. Oh, here we go. We have a question about what is considered a celebration. Okay. I will say the agency does not have a specific definition for celebration. The statutes that reference celebration, they also do not provide a definition. So the agency would use, our standard canons of statutory construction. We'd look at that term is normally used. And I do know that on the applications, and I believe even on the file in use form, there's a description of the event that gets provided. So the agency would look at that. All right, any more questions or comments before we close this up? And again, I'll repeat it, this is not your only opportunity. You can email us, call us, and we'll definitely still receive all of those comments. And then also, there's going to be the standard formal written comment period that happens after these rules get proposed at a commission meeting as well. Okay, it looks like that is all the questions and comments that we have right now. I'd like to thank everybody for your time today, and we will see you next time. Thank you.